What is the scope and standard of duty that an application under Section 11, Clause 6 of the Act 1996 can be subjected to when a plea of accord and satisfaction is taken by the defendant? And thirdly, what is the effect of the decision of this court in interplay between arbitration agreements under the Arbitration and Conciliation Act 1966 and the Indian Stamp Act 1899 on the scope of powers of the referral court under Section 11 of the Act 1996? Just quickly, what we have said is, thus, even if the contracting parties, in pursuance of a settlement, agree to discharge each other of any obligations arising under the contract, this does not ipso facto mean that the arbitration agreement too would come to an end unless the parties expressly agree to do the same. The intention of the parties in discharging a contract by accord and satisfaction is to relieve each other of the existing or any new obligations under the contract. Such a discharge of obligations under the substantive contract cannot be construed to mean that the parties also intended to relieve each other of their obligation to settle any dispute pertaining to the original contract through arbitration. Although ordinarily no arbitrable disputes may subsist after execution of a full and final settlement, yet any dispute pertaining to the full and final settlement itself, by necessary implication, being a dispute arising out of, or in relation to, or under the substantive contract, would not be precluded from reference to arbitration, as the arbitration agreement contained in the original contract continues to be in existence even after the parties have discharged the original contract by accord and satisfaction. Our final conclusion is like this. The existence of the arbitration agreement as contained in Clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant, being one of quantum and not of liability, prima facie falls within the scope of the arbitration agreement. The dispute regarding accord and satisfaction, as raised by the appellant, does not pertain to the existence of the arbitration agreement and can be adjudicated upon by the arbitral tribunal as a preliminary issue. For all the foregoing reasons, we uphold and affirm the appointment of Justice K.A. Pooch, former judge of the High Court of Gujarat, as an arbitrator to resolve the disputes between the parties. But what is important in this judgment is that we have clarified our earlier judgment in Arif Azim. The clarification starts from para 126. We have explained how Arif Azim should now be construed or understood, more particularly in light of this pronouncement. And what is important is, just one paragraph, very quickly, we are running late. Thus, we clarify that while determining the issue of limitation in exercise of the powers under Section 11(6) of the Act 1996, the referral court should limit its inquiry to examining whether Section 11, subsection 6 application has been filed within the period of limitation of 3 years or not. The date of commencement of limitation period for this purpose shall have to be construed as per the decision in Arif Azim. As a natural corollary, it is clarified that the referral courts, at the stage of deciding an application for appointment of arbitrator, must not conduct an intricate evidentiary inquiry into the question whether the claims raised by the applicant are time-barred, and should leave that question for determination by the arbitrator. Such an approach gives true meaning to the legislative intention underlying Section 11 bracket 6 capital A of the Act, and also to the view taken in re interplay. That's how we have decided. Thank you.
With your lordship. May I just give you lordship?
Everybody else, please circulate emails, because once we breach the norm, then I cannot breach it only for seniors and I have to do that for everybody else. It completely destroys the system which I have put in place. Everyone who has a request, please send me an email. I'll look at it by the afternoon today.
But this is not a listing request.
It's not a listing.
Anybody who does not have a listing request, some correction in an order, something is free to mention.
Yes. There's a matter coming tomorrow. We're asking the review today to be put with that tomorrow. That's a request.
That also has to go on an email. That's a listing.
I'll put it in the email.
Listing, if it's on listing, please don't mention. Please put it in an email. I'll look at it in the afternoon today. I promise you I'll do that. It's the same thing. When was the impugned order passed? By 19th, right? So we'll list it tomorrow.
Your lordship, I'm just seeing
List it tomorrow. No, but you could have also said it in an email. Sorry. Circulate a rejoinder.
Circulate a letter in tomorrow's matter listed at item 26. And for the respondent, this needs
too late now. We'll see tomorrow. Yes.
Because I'm mentioning a matter where I've already sent emails for us. Malaj, I've also sent
emails
this morning.
It will be dealt with.
This morning also, Malaj, I'll meet you.
Mr. Shoaib,
just a query. Would your lordship be taking the part third income tax matter or
just wait. I've just told the court master we'll tell you in a minute. Yes.
Lord, I'm sorry, I just one request. There's an order that your lordships had passed last week, my lord. It's an arbitration petition. Lordship perhaps will recall, notes. I had made a submission that the pendency or the reference to arbitration will not impact any criminal proceedings that we might initiate. Because our recollection is the lordships had dictated that in court, my lord, but it's perhaps not reflected in paragraph 3, my lord.
no? But your lordship
we also said in the course of the discussion
that
an arbitration will never affect a criminal prosecution.
But I made that submission, I think.
All right. We don't have to put something. We don't have to put something. Clarify something which is obvious.
Very good.
So before we begin, what we're proposing to do is that we have the income tax part third group. NEET is above that today. We'll at least open the NEET matter, and then we'll see what to do with the part third group. We'll hopefully start with the part third group, but it might just have to wait until we open the NEET matter, because there's some urgency in the NEET matter. Children, young students all over the country are waiting for the outcome of this matter. So, but we are not going to lose session of the income tax matter, because we are now also mentally we are in the matter.
But may I suggest, since we have circulated something yesterday, it can be kept tomorrow also.
Let's at least open the NEET matter today, because let's see the matter.
The others can be discharged, etc. Many are procedural matters, item 4, etc.
So what we are doing is, field number 1, for instance, is about bifurcating. We'll take up item 1. So it's bifurcating matters, etc. That will pass procedural directions.
Like that, when you're
Yes.
The law.
Item 1 is not bifurcating. Item 1 is a batch of cases on fringe benefit tax.
Yes, the fringe benefit.
On some of the name. The bifurcation is item, the gaming matter item, if I'm not mistaken.
Why is that listed for direction? Because item 1 is only listed.
But there are two
Item 1, right, the courtmaster says that we have to pass the usual procedural direction for appointing nodal counsel so that they prepare one common compilation. So tell us who will be the nodal counsel.
Mr. I'll give my AOR's name to your lordship's bench and one from the department. So 2 of us can be there.
Is there a compilation for the department? Is there a compilation for the only petitioner? So now tell us for the petitioners who will be the nodal counsel.
Mr. Kunal Kishore can hold.
And what since you have already put.
Manisha Karya. I've already a compilation.
And for the department, Mr. Venkatraman, are you appearing in the one? You are appearing. Who will be the nodal counsel there? Mr. Divakar. So Ms. Manisha Karya and Mr. Divakar will be nodal counsel. Usual orders. And prepare one common compilation duly indexed with written submission in terms of our last circular. And file it by what date will you file it? Mr. Datta, by what date will you file the compilation?
Your lordship is posting it in August or July?
We'll post it in August, so we'll give you enough time to file the compilation. You can file the compilation and written submissions by the 31st of July and we'll post it in August. Alright, so that seal number 1 is over. That way, we have just one compilation, or it becomes impossible to.
Item 2 will have canon matter, will have put a direction now. It has to be a break bench has to be constituted, not a batch of matter.
So here also can we have one compilation, please?
Yes, we can do a compilation.
Right. So who will be the nodal counsel? Charanya will be the.
Chandrasekhar Bharti will be.
So
panel.
Charanya Lakshmi and Mr. V. Chandrasekhar Bharti. And can you prepare the submissions and compilation by 31st of July? Then we'll keep it in the first week of August and we'll take it up because a lot of matters across India are dependent on this.
Thousands. Canon matter was passed by 3 judges.
Right.
Therefore, it has to be.
It has to be 3 judges.
Thank you. Yeah, so I'd be appealing in district.
It will be before this regular bench. It will be before me and my 2 colleagues. So we are seized of the matter.
As it pleases.
My lord, I appear for Google. Your lordship recalls your lordship.
What we'll have to do is, are the compilations ready in Google?
Everything is done. My lord, give dates in September.
Today we started only because we have the NEET matter and literally lakhs of people the country are waiting for the outcome of this matter.
No, in September, my lord, give dates in September.
Probably in the first week of September, so that we can conclude.
My lord, a little later, I have the Indus Valley dispute before the next meet in September.
Second week of September,
After 15, my lord. After 15, anyway.
Submissions have not been received, the courtmaster says, so you'll have to email them.
That will make sure, my lord, are sorted out.
All right, why don't you give us on the side of Mr. Salve one nodal counsel?
Yes.
We have filed it. We filed it on the 3rd of October. We'll file it again. We'll send an email again. It's been filed.
All right. Who's the nodal counsel on your side?
Mr. Chandelier is the nodal counsel.
Mr. Chandelier. And what about Mr. Venkatraman, your side? We've already appointed nodal counsel. All right. Then make sure that is filed by the 31st of July. All right.
Yes. This again, my lord, is the gaming matter.
Are these absolutely ready for? Hello.
Mandiru 2. We can do it on a week.
So we set down 31st of July for completing the filing of the compilation.
Maybe 15th August may be better, Malik, but I'll leave it to
Anti-profiting batch we can exclude, but amongst gaming, no segregation, my lord. Everything has to be heard here.
Agreed. My friend is right.
One second.
15th August will be better.
This exercise has been done in the registry.
Yes.
The gaming matters we've got separately listed, and the anti-profiteering matters are separately.
Correct.
So they have to be segregated. Now, what we will do is that the learned counsel can. This is being done by Charanya.
The list is made. Charanya has made.
Have you looked at it?
Just check it up, just give it to me now.
All right. Ms. Charanya Lakshmi Kumaran, learned counsel appearing on behalf of the petitioners, some of the petitioners, has prepared a tabulated statement segregating the into single inverted commas, gaming into inverted commas matters from the into single inverted commas anti-profiteering matters. Full stop. The statement is reproduced below. Copy kar lijiye. Mr. N. Venkatraman, Leonard ASG, states that he will have this duly verified within the course of within a week, and intimate the registry in regard to whether he agrees on whether the statement reflects the correctness of the statement. Full stop. This may be communicated to the court master no later than by date de dijiye on the email ID. The compilations are ready.
The counter was received by us in the writ petitions on Monday evening. So we need some time to file the
Rejoinder has to be filed. That may be filed on or before 31 July 2024.
Lordship, some of the transferred matters, the councils indicated that they would also like to make written submissions when we checked with them. So they were waiting for direction.
All right. If any further written submissions are to be filed, including the transferred cases, they may be filed with the nodal council who will add to the common compilation. The written submission shall not exceed 5 pages each. Because
would your lordship set it down on 31st for directions? Would your lordship have it on 31st for directions, Manoj?
We'll have it on the 31st of July for directions. For the directions on the 31st, which is a Wednesday.
Lordship.
All right. We are segregating gaming and the two sets
anti-profiteering.
There's no difficulty in segregating gaming and anti-profiteering. No,
that's all.
Within gaming is not a
no.
So we are not asking for it. No, somebody last time said game of skill should be segregated.
Mr. Venkatraman, now you're giving them ideas.
Yes, correct. No games.
All right. Now, so that covers 4, 19 and 20.
Anti-profiteering some dates.
So 31st of July we'll keep it for directions.
Yes.
Just to ensure that everything is complete, then we list it immediately and here this meeting.
Great.
Obliged. Lord.
Because this is for the gaming matter, now the counter, etc. we have prepared. For anti-profiteering matters, there are no directions in terms of
the circular.
Right. So for the anti-profiteering matters, we'll issue similar procedural directions. Same nodal council?
Can be there.
Same nodal council, same. And by 31st July, that process must be completed.
We can do that. Publish it.
That is neat. Mr. Agde, we'll now stand back the income tax matters. We are not adjourning it for the day, but in view of the importance of the NEET matters, we'll take up the NEET matters, because but all the other learned counsel may step aside and you can have a little time off, but we'll take up the income tax matter because we're not taking up any other heavy matter until we take up that. So NEET only because of the social ramification, we thought we'll give priority to the NEET matter. All right, now
they're all mixed up. 5, 7, 9, and all that.
Now, who's going to open the arguments in the NEET matters for the petitioners?
My lord, my item 5 is slightly on a different footing. I am showing not merely the leakage of the examinations, but I am showing the...
Mr. Dwivedi, where are you appearing in this matter? That is pension matter. I think you are safe today because, if after this, we are going to take up the partner tax matter, which will take the rest of the day. So, but the judge's pension matter is again important and we will take it up probably next week. We'll list it and take it up. Just a little adjustment of the board.
So far as item 7, if not, I can. The writ petition under Article 226 of this candidate is pending before Honorable High Court of Delhi. He has filed writ petition under 32 before this Honorable Court also, saying that I will withdraw that. This is the third time consecutively where he is alleging that my OMR has been replaced, which is actually.
All right. That we will see what to do there, because that's not about the systemic issue, but about his own OMR sheet. There we may be who's appearing. Which one is that? Serial number? 5. So 5, why don't you do this? Go to the High Court. Whether your OMR sheet has been replaced or not, there is not a systemic issue.
High Court has already passed the judgment. High Court has refused to examine this issue. My lord, I had delegated.
So why have you filed a writ petition? You have to file an SLP then.
No, my lord, in 2020 I went before Honorable High Court on the directions of this Honorable Court.
But now High Court is held against you.
In 2021.
21 hoga, 20 hoga, 19 hoga, 23 hoga. But now tell us, what remedy do you have against the judgment of the High Court?
Against that, even if I come in SLP, my lord cannot grant me an admission. My lord, I am saying I reappear in the examination in the
Fair enough. We'll entertain your writ on one condition, that now then we will treat the order of the High Court as attained finality.
Yes.
So we will then hear your writ on the footing that the order of the High Court has attained finality. So you are taking a chance.
My lord, High Court wants to examine the issues. That's the fact.
All right, we'll see. We'll see when the matter is called.
My lord, may I?
Mr. Nagamutu, we are seized of the matter. We know how important it is. It's about our own retired judges. But we have the NEET matter today, so we'll give priority to the NEET matter today. We just indicated to Mr. Dwivedi, we'll try and accommodate it sometime next week, so we will take it up immediately. You'll just give me a little time, so I'll just in the evening discuss the board position with the court master, and then we'll take it, because we have to take it up.
My lord, I'm here for I have the same prayer that my OMR sheet was replaced and the...
All right, let the matter open up now. If everybody just keeps on giving our individual time, who's going to open the hearing, open the argument?
Mine is the first matter, my lord, where they have filed their responses.
So we'll hear Mr. Huda first.
Yes, my lord, I'll supplement whatever he...
All right, and then we'll hear the solicitor.
Your Lordship had an occasion to go through the second status.
Yes, we have seen the second
Now
state.
that is something is crystal.
We have seen the second state.
Yesterday it was.
Yes, I saw it in the morning today. Both my learned brothers have seen the second state.
Procedural. Okay.
In item 5, may I please request that the first pair is, my lord, that...
You're not arguing it. You have somebody before you who is to argue his matter.
So in item 5, I am making a...
But which is the lead prayer? Which is the lead matter? Are you prepared to argue the whole matter on the leak, etc.?
Not on the lead aspect.
Then why are you interrupting the flow of the proceedings? Allow somebody who is arguing the main matter to take charge, right? We'll hear you at the end, no problem.
Lord, 2-3 things at the outset, Lord. As per my Lord's direction, CBI was supposed to file their status report. Filing, we understood it will be filed and it will be supplied to us. And that was the direction.
The only problem is this.
Pardon?
The only problem is this today. I mean, I'm all for transparency. In fact, this is not a sealed cover procedure. Let me be very clear. But today an investigation is going on. Right?
I follow that.
If what CBI has told us in the course of the investigation is revealed, probably the investigation will get scuttled because people will become wise on what are the leads which have emerged in the course of the investigation. So that's the only thing.
I bow down, straight out. My only... You see, the intervention in between will cause a problem.
So what we would like you to do, Mr. Huda, is
Please.
you have to, redaction is not possible in these kind. If it's redacted, then it will have nothing of it will have nothing of substance. You will have to show us, prima facie, on the basis of your submissions, that the leak is so systemic and has affected the entire examination process across the country that we must cancel the examination and direct a fresh examination to be held. That is the area where we want to hear you. And then we'll hear the learned solicitor in response to that.
I will assess this honorable court.
Then, just 1 second. Second, we have some ideas also on what we are going to post to the solicitor thereafter. We would like you to assist us on assuming, if we accept your wider submission that you must have a fresh NEET examination, then that's what you exactly want. Suppose in the alternative, after hearing you both, we are not with you, then we would like you to also assist the court on which are the further lines of investigation, what are the lines of investigation which must be carried out, in the sense that which are the specific issues which must be investigated. So we would like your assistance on both. The other is an alternate argument.
Yes, but that alternative argument has also come in my supplementary note which I circulated yesterday.
Okay, we'll
in the same matter, I have suggested that this is the line of investigation should be conducted to unearth this entire controversy.
All right, then we'll look at that. Later on, we'll read it with you.
At the outset, Lord, I was flagging my handicap in Lord, I'm assisting. I'm not saying that. But the handicap I have in assisting this Honorable Court in this leak matter, one, they have not declared the entire result. They have declared the result of 100 people. And my assistance is information gathered from here and there. UPSC, Lord, in IAS exam, they declared the result of entire people. At least they should have declared the result of this 1 lakh people who get admission. First 50,000 in the medical colleges. And the two handicaps, Lord, may kindly notice, I will have in the course of my assistance to this Honorable Court.
First 50,000. How many seats in the government medical colleges?
56,000. And Lord, everybody clamor for these first 56,000. Even the people below 56,000 may be willing to go for a re-examination.
And how many in the private medical colleges?
52. 56 and 52. That is 1,08,000. Now, Lord, if re-exam happens, literally it is, if all of them do not want re-examination, the total number is 1,08,000 people, not 23 lakh people. The remaining 22 lakh people
have not got admission at all.
Have not got admission. So they are willing.
Except for the fact that if some people have wrongly got into the 1,08,000 category, then somebody below the 1,08,000 can legitimately get into that 1,08,000.
That's right. So, in fact, the balance is this 1 lakh. If all of them 1 lakh don't want re-examination, this 1 lakh on one side and 22 lakh on the other side who would like to take a chance in view of the this examination is marred by controversy. All 22 lakh would like to have a second chance.
That argument, yes, Mr. Huda, there is a problem. Forget the question of leak in this matter. Merely because, say, out of 22 lakh, 1 lakh 8 only have got admission or would get admission, and therefore you are left with, say, 22 lakh students who would want to take a chance. We cannot order a re-examination merely because they want to take a chance.
But I just
re-examination has to be on a concrete footing, that the sanctity of the entire examination has been broken.
I bow down. I just wanted to dispel an impression that the stake in the re-examination is of lakhs of people. No, the stake is of 1,08,000 people. I will have to set up, demonstrate conclusively that we cannot segregate tainted from the untainted. In Tanvi Sabharwal case and the judgment authored by Malot clearly says, in Tanvi Sabharwal's case, the finding was we have identified 44 candidates out of 6 lakhs. The remaining we are not able to identify. So we cannot permit even 10 people.
Mr. Huda, I think you need not labor that point because you're absolutely right on that.
I'm so great.
That if you can, conceptually, that if you can establish that it is not possible to segregate the tainted from the untainted, then the whole examination has to go. Because those basic, you can of course show those authorities briefly to us at a certain point. But when we have looked at the facts, but before we go into the authorities, we want you to address the core of the facts before us.
Milord, I will try to first summarize my case and then elaborate.
All right.
So that Milord has an idea what I am saying.
You can summarize one. My brother Justice Pardiwala would like to know out of 1,08,000, totally how many petitioners are before the court?
Good. But it is NTA can say, well,
NTA, 38 petitions. Now, you're for NTA, no?
Right by the NTA.
So 38 petitions includes the 6 transfer petitions or transfer
petitions before this one would include the 6 transfer petitions
All
made
right.
by the NTA. So 32 petitioners, 32 petitions.
Our question is little. How
many?
8,000.
I represent 10. I'm from
How many are asking for?
Supported by 43 more from
because, I do not know how many, at least 100, the candidate must have called us individually, but who have not petitioned.
I think they have a figure. 108. Mr. Kaushik, if you can just ask somebody, any of your team from the NTA, to just do this physical exercise of telling us even at lunch or after lunch, how many total students are involved in the matters before the, not involved, but how many students have moved the court in this batch of cases?
Lordship, with utmost respect, my lords, that way.
Approximately 108 are seeking reconduct of the examination.
The council, 108 who are seeking re-exam are amongst 1,08,000.
No.
Yes.
No, they'll be outside 1,08,000.
We are outside 1,08,000.
They can't be. They can't.
Because 1,08,000 would get, they have succeeded.
They have not seek re-examination at all.
I represent
So all those who have not been able to
Yes,
clear,
yes.
some people within 1,08,000 are also before your lordships because they say
They will not get into government medical.
they will not get into government.
They will get into it.
In my petition,
Seeking re-examination.
my petition 700. In my lab, there are 5 candidates. One of them.
Now in charge, unless we ask a question to some other council, the others may not interrupt, because otherwise, our line of thinking is also affected. And he is deflected also. He has his thought process in some matter, yes.
But they are not in.
Yeah, among those.
Also, Brother Manu had a point. What is the minimum mark which has been received by the petitioners before the court? We just want, you need not give us an offhand answer, just do it at lunch and tell us.
Can I have one thing, my lord? In 5 petitioners in my petition, my lord. One is having 700. Another is having 600.
How will we be able to, just wait for a minute. Let's have the conceptual basis of the matter. We can't go in individual facts like this. Let's have the concept very clear before us, and then we can see where the balance lies. Yes, Mr. Wood. We'll hear you. We're not going to run away. We are here to hear you and do justice to the matter.
Qualifying marks are 164. Done this exercise. There are 131 students who are not falling within 1,08,000, and they are playing for retest.
131 students.
130. And there are petitioners, and there are 254 who are falling within 1,08,000. They are opposing them. Not that statistics can assist your lordship either way, but factually this is the way.
So 131 students beyond 1,08,000 who want a retest, and
254 they are in the form of IAs, which are implement,
who are opposing.
for opposing the retest. They fall within 1,08,000.
The figures may not always be right, my lords, because I represent somebody who falls within.
Yes,
And whose rank is about 2009. But, my lords, we'll work out the figures in common with Mr. Kaushik.
now tell us also what is the cutoff rank for the 56,000 and for the 1,08,000.
Just one clarification, conceptual. Anybody who is above the 50th percentile qualifies, in the sense that if somebody above them also does not go into medicine, goes into IIT, for instance, there will be a figure. So passing is 164. passing is 164, but admission is a dynamic process, may stop at 1 lakh, may stop at 1,50,000. And depending on the particular quota or reservation or whatever is available. 164 is the cutoff mark. 164 means that you are above the 50th percentile. So about half the people have a qualification to be allotted a seat, but not everybody will be allotted a seat. So it's a dynamic process. There is 1,08,000 seats available. Some of them may not opt for medicine, some may go into IIT, this, that, and the other. The figure will come down. And also depending on whether you have a reserved category or something. So it is not, so it is dynamic, but roughly saying, I think the last figures will stop at 2.5 lakhs, rank-wise. That's
well, let's hear Mr. Huda. Yes, Mr. Huda.
So, my lord, I'm
Can
starting.
you summarize your case, you said?
Yes. I'll just summarize. But give me a speed, please. थोड़ा सा बीच में. Lord, I'm starting with a handicap. I do not have the result. Because of that, I cannot have the data analytics, which the state has placed, NTA has placed on record, giving the bell curve. And Lord, one of the director of IIT Madras is a member of the governing body of NTA. They have run the data analytics process, taking the entire number of 23,33,000 candidates who sat in the examination. If data analytics is to be run to 23,33,000 people, at what stage 10,000 or 20,000 people have sneaked into it? This data analytics running into half a page, which every dot means thousands of people. You cannot detect any abnormality when you draw a bell curve, which is based on 23,33,000. The correct procedure, if at all they were doing it well, the correct procedure was to apply this process to 1,08,000 people. The first 1 lakh people in 2021, 22, 23 and 24. Probably the curve would have been able to catch 1,000, 2,000 people going up and down. Now even 1% is up, is into thousands of candidates. This Honorable Court has not tolerated, even if it comes to a conclusion that 1,000 people have entered into the system of this 1 lakh, which we are not able to detect. This examination cannot be sustained.
Well, that's one aspect about what IIT Madras has done. Now, what about, how do you develop, now you can develop the basic case that you have.
I'm demonstrating that IIT Madras can't be relied upon.
Because they have taken the entire body of 21.33 lakhs.
That's right.
And according to you, that data analytics should have been done on the restricted figure of 1,08,000 and compare that with 2021, 22 and 23.
So great. And Lord, the governing body member is the of NTA is the director IIT Madras. There is a conflict of interest here.
No, but therefore, you take it, I mean, what is at the highest, what does that lead to? Your argument is that the data analytics has been done by NTA itself.
Correct.
It can't be higher than that.
And apply.
That because the director of IIT Madras is also on the governing body of NTA. You are,
Actually,
he's not, they say.
Present
But
he says he's not on the board of directors of NTA.
oh, I see.
He was an outsider who's without expertise.
But anybody from IIT Madras who is on the governing body of NTA?
He was. Somebody else was.
Was means in the past.
In past.
Today, IIT Madras has nobody from IIT Madras in NT.
When was that password when he exited?
But the director who has prepared this report.
Mr. Solicitor, just sit for a second and ask them what the position is so that you can have a seat.
This is not the way it is done. Please don't do this.
Not attended any board, now they are
Member. Member. Any other person who is a member. Then.
अपना पासपोर्ट एंटर करोगे, किसको दिखाओगे? मुझे दिखाओगे ना, किसी और को दिखाओगे, और मैं आपके में अपना पासपोर्ट एंटर करूंगा। अब मैं यहाँ रख रहा हूँ अपना मोबाइल, मैं बस आपके फेस के एक्सप्रेशन को देखूंगा, बॉडी लैंग्वेज को देखूंगा, आप अपनी आंखें बंद कर लोगे। अब आप पहला डिजिट एंटर कर रहे हैं, अब दूसरा डिजिट एंटर कर रहे हैं, दूसरा वापस एंटर कर रहे हैं, तीसरा एंटर कर रहे हैं, जो दूसरा डिजिट है मैं वहां पे अटका हूँ। बाकी का जो पहला है, तीसरा है, चौथा है, वो मेरे माइंड में नहीं है। पहला तो मैंने पकड़ लिया भाई, दूसरे में आई एम नॉट श्योर, बट 0 अगेन 0 एंड 2। ट्रिक करना बहुत आसान है। सबसे पहले ध्यान दो, ऑडियंस से बंदा आता है और पासवर्ड एंटर कहाँ करता है? संदीप जी के फोन में। आप मेरे मोबाइल में अपना पासवर्ड एंटर करोगे, किसको दिखाओगे नहीं? अपना पासवर्ड संदीप जी के फोन में एंटर करके जब बंदा संदीप जी को फोन वापस देता है तो संदीप जी को पासवर्ड पता चल जाता है, और ऐसा इसलिए होता है कि संदीप सर के फोन में लॉक स्क्रीन नहीं थी, बल्कि एक सिंपल सा फेक लॉक स्क्रीन ऐप था जिसने वो पासवर्ड स्टोर कर लिया। ऐसे सोचने वाली बात है ना। संदीप माहेश्वरी तो नॉट फॉर प्रॉफिट चैनल चला रहे। नॉट फॉर प्रॉफिट सुन के ऐसा लगता है कि उन्हें सिर्फ मोटिवेशन देने से मतलब है, सिर्फ ज्ञान देने से मतलब है, उन्हें प्रॉफिट नहीं कमाना है इससे। ऑब्वियसली इस नॉट फॉर प्रॉफिट की वजह से लोग आप पे ट्रस्ट करके आपके वीडियोस देखते हैं। जब आप यही वीडियोस दिखा के लाखों रुपए कंसल्टिंग के चार्ज करते हो तो पॉइंट ये उठता है कि ये पूरा सिस्टम नॉट फॉर प्रॉफिट कैसे रहा। यूट्यूब पे 2.3 मिलियन व्यूज हैं और इसके बेसिस पे वो टॉप एग्जीक्यूटिव्स को बिजनेस कोचिंग देंगे, और इस कोचिंग का चार्ज होगा 26 लाख रुपीस 2 घंटे का। क्लियरली जितने ज्यादा व्यूज होंगे उतने ज्यादा संदीप जी को कंसल्टिंग कॉन्ट्रैक्ट्स मिलेंगे और उतने ज्यादा वो पैसे कमाएंगे। अगर आपको लगता है कि संदीप जी, जिनका मैं भी एक जमाने में ऑनेस्टली बहुत बड़ा फैन था, अब कुछ तो गड़बड़ रास्ते पे आ गए हैं, तो इस पे मैंने कोई वीडियो बनाई है जो डेफिनेटली यू शुड चेक इट आउट राइट हियर।
Subject to further verification. But the IIT, whichever IIT organizes JEE examination, IIT JEE for selection, the chairman of that examination committee is ex officio member in NET, NT. But the office, the director who has prepared this report is not the member. But some Mr. Gopal.
Now, IIT JEE for 2024 was held by IIT Madras or who held it?
IIT Madras. He is the chairman of that IIT JEE examination committee, but he deputed somebody to attend meetings of NT.
Oh, I see.
He ex officio is there to use his expertise.
So. And what role does NTA have in regard to the IIT JEE?
Nothing.
There's no.
He is.
No, just ask the director. So the actual NTA, the actual IIT JEE mains are conducted by NTA.
Yes.
Oh, I see. So IIT Madras would only set the papers, or what happens?
No, they would conduct the examination. Advanced they conduct, JEE mains is conducted by NT.
So mains is conducted by
NTA.
By NTA. That's like the preliminary exam. The mains.
Advance.
No, mains IIT.
May final.
This is only for IIT. Whosoever is intended to get admission in IIT, they opt for the advanced. Otherwise, all other.
They are only the admissions are on the basis of IIT JEE mains and IIT JEE advanced. NTA doesn't conduct that. So IIT JEE advanced is conducted by whom?
NTA.
No.
IITs.
IITs or one IIT?
It is conducted by IITs. One become the organizing IIT. This year it was IIT Madras.
Okay, so like the CLAT.
Yes.
So this year, the IIT JEE Advanced, the organizer was IIT Madras.
Correct. And my lord, he has gone into city-wise as well as center-wise analysis.
Now, when you said that the chairperson of IIT JEE is the ex officio member of NTA, of the government, is ex officio a member of the governing body?
The governing body has no correlation with the activities of the conduct of the exam.
So the IIT JEE, the chairperson. So this time, who was the chairperson?
He was the chairperson. He deputed one Mr. Gopal Krishnan to attend the meetings on his behalf.
No, but who was the chairperson? The director of IIT Madras was the chairperson?
Yes. Because IIT Madras was the organizing body.
So IIT Madras was the organizing body both for the mains as well as advanced, or only for advanced?
Only advanced. Mains was conducted by NTA, by us
entirely. But IIT Madras's director was an ex officio member of the
governing body, which is a kind
of NTA. Of NTA. And is he an ex officio member only for this year or generally?
He would be, whichever IIT conducts the exam.
For that year, he becomes a member of the government. All right,
But I must tell your lordships, my lord, that what is placed in the report is, my lord, for say a city-wise spread of top 100 rankers.
This time the director IIT Madras would be ex officio a member of the NTA, but he had deputed somebody else on his behalf to attend the meetings.
One Mr. Professor Gopal Krishnan. And I have city-wise and center-wise.
That I am explaining.
But deputed professor or doctor?
Gopal Krishnan. Professor Gopal Krishnan. If my learned friend is going on the question of bias, that may not help here. I have sat with him, my lord, I have examined everything which he has done. Yeah, I can show it to your lordships, and lord, it is city-wise, center-wise, and at the national level.
Yes,
Just so that there is no.
That can indicate when your turn comes. All right, now tell us.
Without showing the document, but that city-wise and center-wise, the first table is, my lord, the bell curve of 23,000 people. 23 lakh people. The second table is city-wise top ranker analysis, the top 100, how top 100s are spread over across the cities. Then there is a table which gives
Can we do this, Mr. Huda, to understand your submission? Can we just look at the report of IIT Madras?
Yes, I straight away demonstrate.
Let's go straight there because let us first understand what they have done.
Yes, that's great. Lord, may kindly see the reply filed by them on 10th of July.
Just 1 second. Serial number kaun sa hai bhai?
Additional affidavit dated 10th of July filed on behalf of respondent number 2, Lord.
28 dated 10th of July?
Correct, Lord. That's right. Lord, this is respondent number 2. Annexure A, Lord. Page 12.
Page 950 पर है ही नहीं बोलता. It's analysis of the 17 candidates or no?
Lord, this annexure is data analytics of NEET UG 2024, annexure A.
Lord, it may be part of the petition filed by Shivangi Mishra.
Shivangi Mishra?
Because that was the first.
Yes.
Yes, it is in Shivangi Mishra's case, Lord, because they didn't file it in my case.
Yeah, we got it.
But copies are served on.
Yes,
that is
copies are
report from IIT Madras, pages 12 to 18. Let's see that.
Yes. Now, you see, at page 12 is there's an executive summary given on page 1, and then the charts. Executive summary indicates they have gone all the way to explain. If I can read it, the executive summary.
Yes.
Marks distribution follows the bell-shaped curve which is witnessed in any large-scale examination.
Just 1 second.
Yeah. Executive summary, short summary. Marks distribution follows bell-shaped curve that is witnessed in any large-scale examination, indicating no abnormality. City-wise and center-wise analysis done for 2 years, 23-24, to find out if there are any abnormal indication. Analysis is carried out for the top 1.4 lakh ranks, given that the total number of seats across the country is around 1.1 lakh. This analysis is granular enough to indicate any abnormality had a large number of students gotten into high rank top 5% due to malpractice, or if students from a particular exam center or city were benefited. The analysis show that there is neither any indication of mass malpractice nor a localized set of candidates being benefited leading to abnormal scores. I would say this is beyond their brief, what they are stating here. D. There is an overall increase in the marks obtained by students E part. There is an overall increase in the marks obtained by students, specifically in the range of 550 to 720. This increase is seen across the cities and centers. This is attributed to 25% reduction in syllabus. That's not their case for them to say. In addition, the candidates obtaining such high marks are spread across multiple cities and multiple centers, indicating very less likelihood of malpractice. Lord, if I can take just one moment here. NTA, the Government of India, in their reply is talking that they are attributing 2 reasons for this exponential inflation in the marks. 2 reasons are there is 22 to 25% syllabus reduction and hence the inflation. 2, increase in candidates. Nowhere there is a whisper that there was increase in the syllabus that we have placed on the top. If not more, at least corresponding. So, if I can say so, the reply is not giving a full disclosure for oblique reasons. If they are talking about deleting the syllabus, they should simultaneously talk about increase also. At least they should disclose it. I will show the increase part of the syllabus. So there is an increase and decrease both. But this IIT Madras is talking about 25% reduction. Probably they are not given the papers that there is an increase also. And why IIT Madras will not?
Let's look at the data.
Yes. Now kindly see the first table. This table, blood, is for 23 lakh people. They say it is a bell shape. And any large examination will have a similar kind of a shape. And hence, there is no red flags. Now, starting from extreme right, where 720, now it is going up to the marks. Now, at every stop, there are thousands and thousands of people. This one line, which encapsulate about 24 lakh people, cannot give them any abnormality. If 10,000 have gotten into this system through a back door, and there is an inflation. Inflation is admitted, leak is admitted. They are trying to justify it that it should be the same curve, and it is the same curve. So this is no indication that there is no abnormality. That is my respectful submission. Because of the data is too large, which can't be caught. Granular variations can't be seen with this large data.
Yes.
Now, may kindly see the next table. They say the CT-wise top ranker analysis. Plot of the marks obtained versus number of candidates for all the candidates who took the examination. Similar analysis was carried out by NTA for every city, and the results followed the same distribution. This was verified by IIT Madras team. This further strengthens our view that there was no major abnormality. There can be abnormality, but there is no major abnormality which can be caught by this system if this Python software is run through 24 lakh students' data. Now, may kindly see center-wise top ranker analysis, which they say that there are city-wise. There are 571 cities. They say first top 100 are evenly spread, and then the data they give is only with regard to 17 students. Bangalore, Karnataka 5, Lucknow, Uttar Pradesh 4, Kota, Rajasthan 3, Tamil Nadu 3, Patna, Bihar 2. Total is 17. Why are they shying away? If they have run it for top 100, they should give for top 100. That will include Hardayal School, Bahadurgarh, which had 8 candidates from the same center. Now, they are leaving us in darkness because they have the data, we do not have a data. So whatever they are saying, we are trying to analyze and find that is it correct or not. Now, the same story runs through all their tables. Kindly see the next table.
I can give, there is no difficulty. Just to
all right,
give the
all right.
context,
I'll read the narration also.
Only a minute, just to give the context. This chart shows that out of students who got first top 100, and we are not counting those 1563. Please don't count them because they become a separate class.
My only limited objection is why send only for 17 people? Why don't they give a data for 100, top 100?
I'm answering that. Please allow me to, if you listen to it. In Bengaluru, just to show the difference, in 23 there was 1, here it is 5. Maximum in India, the city which got 100 ranker is 5 in Bengaluru, Lucknow 4, Kota 3, Namakkal 3, Patna 2. Rest are 1, 0, 1, 0, 1.
But do you have the breakup of the top 100 ranks?
Yes.
Top 100 ranks, if you can give us what cities do they come from? Because we have now got the data for the 17, 5 and 4, 9 and 3, 12 and 15 to 17.
Rest would be 1, 0, 1, 0.
If you can just give us in a chart, you can set it out and give it to us and give it to the others also. That if you take the top 100, which are the cities from which they are?
No, with your counter affidavit, page 118, we have shared the 100 side also, and we have based it.
Just give it to us separately right now. You have it right now, just give it to us.
Where is it? It is page.
Your counter.
Counter of NTA.
One pick, yes, sir.
118.
सौ कहाँ से बने? To 91 places, but these 5 are top. Bangalore has maximum students, 5 who are in the first 100. Rest will be 10, 10, 10, etc.
Affidavit on behalf of NTA?
Yes, my lord, 118, annexure R90.
A19.
R90. PDF page 121.
121.
PDF 120.
121 is some wakalatnama.
Annexure
Analysis of top 110.
R90.
Counter affidavit on behalf of NTA?
Additional affidavit of NTA.
Additional affidavit of NTA.
The petition number would be petition 335 of 2000.
Correct. So one Binod Kumar Sahu is the deponent?
Yes.
Right. Sorry. There we have got the annexure A1 is a performance analysis of 17 candidates of Patna, Bihar.
Yes.
A2 is copy of screenshots of messages.
Correct.
Now, which is the chart that you are referring to?
118. In the entire country, the analysis of top 100 candidates.
Where is that actually?
That exactly, my lord, annexure
118, my lord, annexure 19, R19.
118.
Additional. It's continuous page PDF 2070. 1070.
There is no top ranker. This is the additional. So, my lord, here given center-wise toppers for all 100.
Right. So first is Guntur.
That's it.
But can your lordships come to 121?
Yes, we got it.
We have 121.
Yes.
Please see Lucknow.
See which one?
Lucknow, my lord. Uttar Pradesh, Lucknow, my lord. Left hand side, first column, Uttar Pradesh, Lucknow. 2, 1, 1. Your lordship gets, my lord? Lucknow, Uttar Pradesh is the state, Lucknow is the city, and SDSN Mahavidyalaya is the center. From that center, out of 100, 2 candidates fall into 100, first 100. Then in Lucknow, Loyola International, 1 student, and Uttar Pradesh, Lucknow Central Academy, 1 student. Total up to 4. And therefore, in the report of the IIT Madras, they mentioned Lucknow as 4.
Lord, may at the same page, Lord, may kindly see at page 120, there are 9 people, 8 people from Jaipur, which they have not captured in the table. Kindly see the Jaipur, Lord, page 120. Yes. Jaipur alone has, Lord, 9 people.
Sir.
They have captured 2. They have not captured 9.
You're right. 1, 2, 3,
9.
4,
It
5,
is 9.
6, 7, 8. 9 probably.
No, 8 seconds.
7 people from Bihar, my lord, in this.
Uttar Pradesh, we get
are only 4 out of total 23 lakhs who appear. But just to show that if there would have been any leakage or malpractice, in one center there would be a spike. That's the intention.
Bihar, there are 7, right?
Yes.
Bihar, there are 7. Yes, my lord.
State-wise, Bihar, there are 7.
Yes,
right?
Yes, my lord.
Then Haryana, how many? Gujarat, there are 1, 2, 3, 4, 5, 6.
Haryana 3. 4. Haryana 4, my lord. And Lord, may kindly notice Haryana 4 is in a situation, if I can be given a moment here.
Yes.
There was one Hardyal school in Bahadurgarh where 8 people were from the same center. And the story of that center is, my lord, the paper distributed in that center, 500 odd students, was taken from Canara Bank. Paper was
a different issue.
That's a different issue, but I'm showing it. It has a relevance here.
But Haryana, there are 4. There are 4 in the top 100.
Lord, there were 6 people in the top, which are not, they are not there now. Because what happened, my lord, in Bahadurgarh, Lord, that's one other glaring thing I just want to state here. NTA never disclosed it. That in Hardyal school, Jhajjar, the question paper taken from Canara Bank was distributed. That paper was taken. There was absolutely no delay in distribution of paper. The principal of the school is on record on YouTube. Even here it can be shown. She says that we collected paper from SBI as well as Canara. Ultimately, the instructions came that you distribute paper from. Allow me to state it.
It's a different issue. We will not
different issue that which you have never disclosed on affidavit till now. And I will demonstrate in Lord. That's a very clinching issue, which they are getting agitated on that. Paper taken from SBI as well as Canara both. The paper was distributed, which is taken from Canara Bank. The entire country was giving the paper taken from SBI, but Hardayal School, Bahadurgarh paper was given, distributed, and ultimately full time was given and paper was taken on the basis of Canara Bank. Answer. Now, Lord, what happened is, just if I can complete it, what happens is the principal says that after about 40 minutes I conveyed it that we were told Canara Bank and now the students are attempting Canara Bank question paper. And the instructions to her was that all right, if it's already 40 minutes, so let them do Canara Bank. They did Canara Bank. Ultimately, what they did not disclose it to anyone, but they gave grace marks to everyone in that school. And because of those extra marks, 6 people got 720 out of 720. 2 students from the same center got 718 and 719. Thereafter, Lord, this was the grace marks.
Of course, thereafter a fresh examination was held.
No, Lord, Lord, that is impinging upon the entire system they have. Now, initially, they arbitrarily gave grace marks for which they were not entitled to at all. Now, this is how they have given grace marks across the country. There was absolutely no justification because they have not come clean on that. Here, they should have said, in Bahadurgarh, a different paper was given. That is why we are holding a re-exam. Fine. First, they said that there was a delay in distribution of paper. There was a loss of time and hence grace marks. When they were caught in this court, then they appeared before the Honorable Other Coordinate Bench and said, now we are having a re-examination, so please do not go into how we gave the grace marks to this 1,561 people. 1,563. So the question that how they gave grace marks to 1,563 people on account of loss of time has not been examined by this Honorable Court. They, in their reply, they say that the issue stand resolved because we have had a re-exam. My question is, Lord, that how in the first instance they identify 1,563 like the center in Bahadurgarh, and to hush up the matter they say we have a re-exam. Now, Lord, if it was on account of loss of time, they should have given opportunity to everybody in the country. That wherever there is a...
Mr. Huda, that has attained finality. Our court dismissed that, our court has upheld the re-examination. Initially they decided to give, grace marks to everybody. That was, when that was done, there were representations, they said. They told us last time that there were representations. Thereafter they decided to revoke that because a fresh committee was appointed and they decided to have a re-examination. Is that correct?
My respectful submission.
I may have to interrupt here only for a moment, my lord.
Later.
Lord, my respectful submission is not this. In the first instance, they indulged into pick and choose for identifying 1,563. One classic example is of Bahadurgarh. Then, Lord, nobody knows how they picked up 1,563. And re-examination, Lord, the people who were not entitled to get this chance again, got the chance again. And out of this, Lord, number, out of the total, out of 1,563.
Out of 1,563, how many make it into the 1,08,000?
Yes, Lord, that's an interesting question. They have not disclosed. But out of 1,563.
Then tell us. That's the proof of the pudding is in that. Yes. Out of the 1,563 who got the retest, how many actually have made it?
Lord, 8 top ranker, which included 8 top ranker from one center.
Right. We'll find an answer to that.
Now, Lord,
see, I've done now in the top 100. Huda,
one fact.
When you are arguing, I've just from that top 100, I've done an analysis.
Yes.
The maximum from the states, you said they had disclosed data only for 5 states, 4 or 5 states. Now, Andhra Pradesh got 7 in the top 100. Bihar 7. Gujarat 7. Just check this up. Ask your team to check it up. I've just done it manually. Andhra Pradesh 7. Bihar 7. Gujarat 7. Haryana 4. Delhi 3. Karnataka 6. Kerala 5. Maharashtra 12. Punjab 6. Rajasthan 19. Tamil Nadu 8. UP 6. And West Bengal 5.
That's right.
So it appears that this spread in the top 100 marks is distributed across the country.
Look,
This covers 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 states and 12 states and 1 UT.
That's right. That's right. On this 1563, I just want to point out one fact. The people who got re-examination opportunity,
it is
out of them
95 centers.
773 did not pass the basic marks in the
100 candidates. Our affidavit, my lord, says first 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities within 18 states and UT of the country. 69, my lord, in Vanshika Yadav state.
What have you said? That the first 100?
In this regard, just read, my lord. It is submitted that allegation of the petitioner that number of students scoring high marks are only from certain center is completely unsubstantiated. In this regard, the result of top 100 candidates was analyzed and it has been reported that they are distributed across 95 centers located in 56 cities.
Yes.
Within 18 states or UTs of the country. This diverse distribution highlights the widespread participation and competitive spirit among students from different regions and educational backgrounds.
Mr. Huda,
This is not
you on the other aspects. But if you look at, as they say, first 100 candidates are distributed in 95 centers in 56 cities in 18 states. Apart from that, as we said, the maximum we have taken in students at least 5 or more per state. 5 or more per state. We find that distribution in 12 states and 1 union territory.
Yes, sir.
With the highest being Maharashtra, which is, Rajasthan 19, followed by Maharashtra 12, followed by Gujarat and Bihar 7, and Karnataka 6.
Lord, yes, Lord.
For us, my lord.
67. The 67 students.
Yes.
Who secured 720 out of 720.
They are also, my lord, reduced now because of the re-examination.
Now tell us, originally 67 students.
Yes,
Got
720 out of
720 out of 720.
Yes.
Now, how many of those were in the, I think 17 were in that 1563, no?
Yes. No,
44.
How much? 44?
Initially they are reduced. 7 were there. Lord, I
got
gave
reduced? Yes.
Got reduced to 61 because of re-exam at Bahadurgarh. And it's 44 we are attributing to the aspect of one question paper in which 2 options were marked correct. As a result whereof, it's 44 candidates got the benefit of extra 4 marks, making it to 720. If those 44 are removed, then toppers in the entire country are only 17.
So 44 students got the benefit of the grace marks.
Grace mark.
Not grace marks, full marks for when there was an error in the NCERT book contained the wrong answer.
So there were 2 correct answers Yes, that's what.
So anybody who gave either the NCERT answer or the actually correct answer was given graded as correct.
If they are removed,
they were 44.
yes, because they would otherwise get minus, because this is a negative marking system.
Because you didn't go by the NCERT, your booklet didn't go by the NCERT answer, but what was truly the correct answer? They say that, look, the earlier edition of the NCERT book had also this answer. So you treated both as correct answers, and those are 44 students.
And total, my lord, are otherwise 17, which in a multiple choice question, my lord, framework is possible in that out of.
So now, as it stands, 61 students across India get 720 out of 720 today.
Yes.
Out of which 44 students have got the benefit of that one question where there were two correct answers were treated as the correct, two options were treated as correct answers. So balance 17 really.
If 44 are
100%.
No expectations.
Now tell us one thing, out of these 61 students who have now got 720 out of 720, or let me put it this way, in the top 100, are there any cases where students have changed their centers? In the entire exam, Mr. Kaushik, how many students changed their centers in the entire exam? 23 lakhs. We'll go step by step. In the 23 lakh, total number of students who appeared were 23.33 lakhs. How many students had changed their centers out of the 23.33 lakhs?
Yes, the center allotment is only on two aspects, only two factors. One is permanent city and the current city residence. We do not give any specific option with regard to the change of center. The correction window is opened up. In that, the field may be changed by the candidates, which will not come to our knowledge.
So that will be permanent or the current city?
Yes, only two options.
So once you are registered, you can't change your center.
What they do is, in the name of corrections, some students change the center also, correcting the parameters or the fields of the application form. We give correction window for some time. During that process, only the possibility of change of center.
But you will never know it.
No minutes. That also has to be on the basis of the address.
But you don't have the fields which are originally filled in by the student and the corrected field.
So far, as of now, the system doesn't catch that.
So we don't know how many students actually changed their centers when the window for correction was open.
We know the correct number of the students who utilized the reopening of the window, in which 15,000 students utilized the inlets correction model.
No, one second. No, one second. 15,000 students utilized the window which was kept open for making corrections in their applications. Now, of the 15,000, how many had corrected the field of the center?
They shy away from
One second.
I'm sorry.
Yes.
Lord, for that, that they should open this window. Rajasthan High Court
window to correct the fields. The window to correct the fields. How many days was that window kept open?
2 days only.
What are the days?
9th and 10th of April.
9th and 10th?
This is not for correction. This is not for correction, my lords.
One second. We'll ask them.
It's actually incorrect.
One second, Mr. Kaushik. The window to correct the fields. How many days and when was that?
24. List of dates. On 8th of April, page 99 of 99 correction. No, don't say.
Now tell us one thing, one more thing. The candidate, when the candidate fills in the application form online, does the candidate have to fill in the city or center?
City.
City only.
City only.
Center is allotted by NTA, by the computer. So what they can change is the city, right? Okay. So if a candidate has, say, filled in Guwahati, that candidate during that window can change it from Guwahati to Lucknow.
Yes.
But no candidate can decide on the center. Is that correct? Centers are allotted only by NTA. Just check, is that correct?
By computer system.
By the computer system.
Center allotment is only 2 days or 3 days before the NEET's exact date of exam. So nobody would come to know which center is going to be allocated.
But that's not an issue. Differently from center will be in the same city.
To correct fields, you are saying?
18th March to 20th March, 18th
Is it correct? 18th March to 20th March?
18th March to 20th March and 11th April to 15th April.
All right, 1 second.
11th to 15th was additional. New people came 9th.
And 11 to 15.
Yes, it's apparently 9th and 10th.
9th and 9th and
Now tell us one thing. How many came in? How many corrected their fields between 18th and 20th March?
That NEET's data is to be found.
But you said that 15,000, no?
That is NEET's when additional slot was opened on the basis of the court orders and representations. Further time was given to make fresh applications.
In April?
Yes, please.
So 15,000.
Yes.
24,000.
All right, 8th April to 15th April. 11th April to 15th April, you said, no?
8th April to 10th April.
No.
Correction window is 8th April to 15th.
Notification was 8th April dated, and the window was open for 9th and 10th for new registration. For new registration, not for correction. And for correction,
in which?
Sir, I am reading for you from your affidavit and from your document.
What is the window?
I was at page number 99.
Just read it.
Page number 99. This is a public notice dated 13th March 2022. The subject is correction in particulars on the online application form of National Eligibility cum Entrance Exam UG 2024. Now, my lord, I am reading the box, the relevant part. NEET 2024 UG. Duration of correction 18th March to 20th March 2024 up to 11:50 p.m.
Right.
Field for correction. So he is even not disclosing it, that what field. It was specifically mentioned that field for correction is as per Annexure A, and that Annexure A was not. Annexure A was filed on the next page. All fields. This is very important.
So between 18th and 20th March, you could correct all fields.
All fields and update documents except the contact mobile number, email. So other than
all
everything
right.
has
Now,
to be
which was the second window? We got the first window, 18th to 20th March. What is the second window?
The second window is 9th of April and 10th of April. For 2 days, the second window opened for a new application, a new registration.
At page
and
number
that is for 15,000. They will not say that it is, this is unprecedented, it never happened earlier. They say that they were directed to do this by the Rajasthan High Court. Rajasthan High Court order is on record, which pertained to only one candidate. And High Court said, for this candidate, you permit him the registration.
So 9th and 10th April 2024, you say there were 15,000 fresh registrants.
24,000. As per our information.
Now, all right, let's ask him for Kaushik. Mr. Kaushik, now 18th to 20th March 24, how many corrections? That is the window for corrections. Do we have figures about that?
That we will have to work out.
All right, and 9th to the 10th of April, how many new applications can?
That according to our information, we have given the data minutes 15,000 applications. New applications were received.
We'll take your data. It's official data.
And my lord, one more important
change of center is concerned. The petitioners have focused only at Godhra. In Godhra, the change of center was by only 34 persons, out of which only 16 could be allotted the change of center.
And
16
they are not
candidates
getting any admission.
They are not getting millets any.
So come again, for change of centers.
Yes.
Was by NTA, you changed the center.
By the candidates,
Permitted change.
Yes.
No, but we took it that a candidate has no choice of change of center.
Correction of city. City. I stand corrected.
Right.
City.
Right. So,
for example, Jaipur to Gujarat. And out of...
So do we have, overall, do we have any data on how many students all over the country, say in the first 1,08,000, we'll now focus on 1,08,000, no better, had changed their cities?
We will get that data, but we have got the data of Godhra only. It's because the Godhra was the only...
So how many of the 1,08,000 would have changed their cities? We would like to know that.
That will be possible.
And we would also like to see the distribution of which were the cities that they changed. Was there any change in respect of one of these suspect areas, like Hazaribagh or Patna, or is there any concentration in the change of cities to specific cities?
There is one interesting statistic.
That will give us some idea.
I have seen one...
Is there any skew in respect of those who got registered between the 9th and 10th of April 24? So after lunch, we are just short of lunch. We'll just break for lunch. After all this mental exercise, we also need a little lunch. But what we want to know is this, that those who changed their centers, how many of those have made it to the 1,08,000? That's one. And second, is there any skew in favor of those who had changed their the cities on the 9th and 10th?
We have let's roughly work out.
That's very language. Some people change their language. They said, please give us a Gujarati medium, for instance.
Or language. Just give us also
so
language. So concentrate on 9th and 10th of April. How many students change? How many of the fresh registrations? First, fresh registrations also could change their centers?
Yes. Fresh registration date is after which the...
Can they change the center during that period?
New application is totally different. New applications are completely different.
When an old student
Acha, one more. Only confined to one student. Then how did you open up the portal for on 9th and 10th of April 2024 beyond that one student, as a result of which 15,000 students registered? Just 1 second, we have something very important. We'll forget it otherwise. Out of the 15,000 students, how many are in the 1,08,000?
Correct. The reason is, I can give...
Mr. Kaushik, just talk to your staff at lunch and come back after lunch.
Advocate Nadumara here. I think our discussions are going a little off. My lord, that's
why Nedumbara is there, to ensure that we don't go off.
I may be permitted to address your lordship for just 5 minutes.
Of course. Who said no?
No, my lord, before you further proceed, my lord. I was patiently listening everything because I think the whole issue.
One second. Yes. One of your colleagues is in charge of the
I only want one sentence to be permitted.
After he finishes, we'll hear others.
No, Lord, I only wanted to say one sentence. Hear me in one sentence full.
One sentence.
One sentence only. The whole question before the court is whether the test should be examination be cancelled or and a re-examination to be conducted. The discussion is far away from that.
No. This is the heart of it. We have to look at the evidence, the underlying evidentiary record to see whether
But that is a major administrative decision. It is not depending on a minor irregularity here or there. It's a major administrative decision. For a minor irregularity here or there.
All right. Mr. Nedumbara, 1 second. We were a little confused. Are you on this side or on that side?
No, I am for the petitioners and my submission is...
You are saying no retest?
No, my lord, absolutely. Only a way is to conduct a retest.
Okay.
And my lord, I want to use a very soft
saying more
terminology, very soft terminology. I discussed with the IIT professor, he used a strong terminology. I'm not using it. He used the terminology the professor used was the, my lord, the IIT report. He said, my lord, there are three types of lies. Lies, damn lies, and now IIT report.
Let's not.
No, I'm not using. I'm not saying that. I'm
use adjectives.
No, I'm not using.
That's not fair, Mr. Nedumara. Also, 1 second. Let's not just damn a premier institute. It's so easy to say something about a premier institute. Give us 4 facts. Give us 4 facts.
No, my lord, I'm very soft on that.
Give us 4 facts.
My lord were to hear the cold.
If I can point out just one aspect.
Exam, my lord.
But if I can just say one aspect before my lord.
All right, we'll come back after lunch. Yes, man. Your Judges Association, man. Today this will go on. So we'll take a pension matter for judges. We'll probably take it up next week. You're safe today. You can.
Grateful, my lords.